Hello, everyone. This is Attorney Andre McKinney Dorval, licensed immigration attorney located in the state of Florida. In this video, we are talking about the latest DACA updates. Now, a brief summation. Back in January, the appeals court issued a decision finding that parts of DACA were unlawful. Now, what the court in essence found is that parts of DACA were not consistent or in line with the Immigration and Nationality Act. However, the court's ruling back in January, it did a couple of things. Number one, it allowed the DACA program to continue while the case is being litigated, which in turn meant that DACA recipients in all 50 states could still renew their DACA applications. The decision also upheld the provisions of DACA that provided protection to DACA recipients from deportation, and that includes forbearance from removal. Now, what the Fifth Circuit Court of Appeals decision found to be unlawful were the provisions that spoke to work authorization and lawful presence. Now, let's fast forward. Last week, the appeals court issued its mandate. A mandate is just a simple way of saying, lower court, we are sending you back this case that was before us, and we want you to go ahead and begin to implementing the provisions of the decision as we have handed them down. That happened last week. So this case is now back to the trial court. And what the trial court is now tasked with doing is implementing the decision that the court ruled on. Now, when it goes back to the trial court, what the judge is going to have to do is he's going to have to figure out and determine, how do I implement the appeals court decision where they found protection from deportation lawful, but the work authorization portion they found to be illegal? How do I sever that to implement the decision? That is what the trial court is now tasked with doing. Now, I do want to stress that the separation and severance, protection from removal or deportation, and work authorization, that separation, severing the illegal part from the legal part, that's only going to apply to DACA recipients in Texas. Now, question, what does this all mean for current DACA recipients? Well, for right now, DACA recipients can continue to renew their DACA along with the benefits of DACA, such as work permits and protection from deportation. This also includes Texas. As I said, the trial court is now going to have to figure out how to implement the appeals court's decision. And that's going to probably take some time. Now, at some point, once the trial court figures all of that out, the benefits of renewing DACA will change, but it will only change for DACA recipients that are in Texas, which means that those in Texas will no longer be able to receive employment authorization, but they will still continue to have protection from deportation. Now, what does this mandate, or now that it's back at the trial court level, what is that going to mean for initial DACA applications that are pending? And guys, there's approximately 90,000 pending initial DACA applications. Well, the question really remains, is the current administration going to follow what the appeals court decision has ruled on? Are they going to follow the court's order and begin to process initial DACA application, which would include the pending applications? Because as it stands, as of today or the publication of this video, the Trump administration nor USCIS have issued or offered any guidance in response to the court's mandate. So as of right now, no one knows how the Trump administration and USCIS is going to proceed So this is really a wait and see. Next question. What about individuals who never applied for DACA to begin with because they missed the cutoff because of all of this litigation? What if they would like to apply? Now, based on the ruling from the court, the ruling and in theory, a first-time applicant should be able to apply based on how the court order reads. However, in this climate with mass deportation, any application that is submitted to USCIS, and remember, guys, we did a video that talked about USCIS now has the ability, if a benefit or an application is denied, they now have the ability to issue NTAs. Any application that is submitted to USCIS needs to be evaluated for risk factors because of the climate that we're in. So if you are someone who is a first-time DACA applicant, you definitely want to work with an attorney to evaluate the risk factors concerning your submission of an initial application, because you would be submitting your personal information to the government. Now, with everything I've indicated to you, with the summary of the court's ruling, with where things are, and the mere fact that the Trump administration and USCIS has not offered or issued any guidance as of yet, DACA still remains at risk, unfortunately. And this includes as well the possibility of this continuing through the court system. So as of right now, there's really no absolute certainty that the litigation on DACA is in fact over, because the Fifth U.S. Circuit Court of Appeals is an appeals court. It is not the highest court in the land. I also want to share with you that it's being reported, it's been issued that the Trump administration is removing DACA recipients from being able to receive insurance benefits under the ACA. So with actions like that, it only raises more uncertainty and, might I say, actual doubt as to whether or not DACA is really, truly no longer at risk. Guys, as this DACA litigation and anything that the Trump administration or USCIS may put out, I will certainly keep you guys updated. If you are someone who is thinking about applying for DACA for the first time, do consult with an attorney, because there are risks given the climate that we are in, and proceed with caution. Guys, this video was for general information purposes only. Be sure to work with an attorney. I do thank you for watching this video, and I thank you for all of your support. Please be sure to like, share, and subscribe, and I will see you in the next one. Bye-bye.